So let's talk about what a revocable living trust is. It's an estate planning document you sign during your lifetime. And like most revocable living trusts, if you create it, you are the grantor, also called a trustor. You are the trustee, meaning you're the one who is in charge of managing the trust and its assets. And you are also the beneficiary of the assets. So you are everything. You get to do everything. It's like you didn't even create a trust, but yet you do have a trust. So this doesn't make sense. A revocable living trust uses your own Social Security number for its tax ID number. You don't have to file a separate tax return. So again, this kind of leads to some confusion. How do I operate this trust? And that's where people run into troubles, especially if they try to do this on their own. In order for a trust to be effective, a revocable living trust, you need to fund it. How do you fund a revocable living trust? Well, if you have a bank account, you need to retitle it from your name into your name as trustee of this trust. If you own real property, you need to have a deed filed with the county that changes the title of your real property from your name to your name as trustee of the trust. So funding the trust and maintenance of the trust and making sure all assets that you have now or that you acquire during your lifetime are titled in the name of the trust is imperative to its successful operation. That's where people run into troubles, is that they just think it's a one and done. I signed the trust, put my house in the trust with the attorney's help, and you go on with your life. And what happens at the end of the day? Typically what happens is by the time this person passes away, they've opened up other bank accounts, not in the name of the trust. They may have bought other real property, not in the name of the trust. So on their death, yes, the trust will govern the direction of where the assets within the trust go, but will have no effect on the assets outside of the trust. And when that happens, which it commonly does, the assets outside of the trust need to go through probate to be captured by this, what's called a pour-over will, be brought back into this trust, be brought into this trust, and then be distributed under the terms of the trust. So you have not only a trust administration process, which is not in the court. It's something that is done with the help of an attorney, hopefully. Hopefully you don't try it on your own, because it is not that simple to do a correct trust administration, but at least you're not in the court. And with a probate, it's going to be in the court. In Washington, our probates are typically non-intervention, which means the court is not involved hardly at all, but they're involved to the extent that we filed the petition and the will. In other jurisdictions, the court is completely involved in the process, and that's a jurisdiction where you probably want to try to avoid a probate. So one of a huge benefit of the revocable living trust is avoids probate. Practically speaking, because of a lack of maintenance and understanding of how the trust works, you don't avoid probate. So if you have a revocable living trust, keep in mind, it is not a one and done proposition. You need to understand it. You need to make sure that all your assets that can be in the trust are in the trust. Then you're going to have a much more successful outcome. A trust is also intended for management purposes. And what I mean by that is if it's your trust, you created it and you lose capacity, yes, you're going to have a durable power of attorney, but you're also going to have a successor trustee named under the terms of the trust in order to allow somebody else to manage the trust that you can no longer manage.